We welcome now Christopher Green, law professor at the University of Mississippi Law School. Professor, good to see you, sir.
Good to talk to you. Getting the audio using the backup system with the phone here.
Gotcha. We see you. Yeah, man. Thanks for joining us. So, let's. Of course, we got the big Trump hush money trial going on today, but give us a brief update on what's happening at the Supreme Court. I know you track that with regularity. What are you seeing there that folks should be aware of?
Well, there's two of the big ones. So we've got, I think, still about 10 big ones on the board between now and the end of June. But two big ones from the last and they seem to be releasing them on Thursdays. That seems to be the new mode. So tomorrow morning, I think they're gonna have something. May not be a big one, but it might be a big one. But last Thursday, they had the Alexander case. This is a South Carolina redistricting case about. So this is not the Voting Rights Act, but this is just a direct 14th Amendment challenge to racial gerrymandering, or a claim about racial gerrymandering in districts. So you've got this one. South Carolina, I think they've got 7 districts, and one of them is this long, skinny district up the beach. And then there was some kind of it was really kind of on a knife's edge at different times in some of the elections. Was just a little bit Republican, some elections just a little bit Democrat, others, and the Republican legislature said, well, let's make this a safer Republican seat. And the question is whether they're just up to politics, whether they really wanted to have a more Republican seat, or whether they wanted to have a more white seat. So the difference. So we have this term in voting rights stuff, BVAC, the black voting age population,
yeah.
And so whether it was 17% or 21%. So the way we do it in voting rights, we have these 3-judge courts. So these are 3 people acting as a trial court. So you actually have one person from the appellate court and then 2 different district judges. So we've had this in Mississippi a couple of times, but basically, so it's a long opinion, and largely about the standard of review that the U.S. Supreme Court has. How carefully are they going to review these findings of fact? Basically, the trial court said, well, we think it's about race. And the majority of the Supreme Court said, well, we think it's about politics. We think it was clearly erroneous. So a lot of it was about the clear error standard of review. Justice Thomas had a slightly more radical view, or maybe a lot more radical view. He thinks the 14th Amendment doesn't generally guarantee voting rights at all. The 15th Amendment does, because that's a ban on racial discrimination in voting as such. But Justice Thomas actually indicated he had done this a couple of years ago, kind of given a slight indication that he had this view, but he was a little more emphatic, and I was quite gratified he actually relied on my work a little bit. Had a reference to my stuff on the Equal Protection Clause, which I say is about protection, not rights in general. You have to go to the Privileges or Immunities Clause to get rights in general, and those are just civil rights, not political rights. So anyway, Justice Thomas is kind of, unfortunately, in the Alexander case, just kind of talking to himself. None of the other 8 looked like they were too interested in that. But that was one of the big interesting ones from last Thursday. The other big interesting one was the big CFPB case. So the Consumer Finance Protection Board, Congress gave them a delegation of authority to basically fund itself with money from the Fed in perpetuity. So it looked like a lot of people like basically congressional abdication of their responsibility to keep a tight rein on the purse. And there's a provision about the power of the purse. Article 1, Section 9, Clause 7 says you can't take money out of the Treasury except by law. So there's a question, can Congress just say, well, spend whatever you want up to a very, very large number for as long as you want? Is that an okay thing to do under 197? And the court actually speaking through Justice Thomas. So he does not get a whole lot of majority opinions where he's tackling things this interesting and juicy in terms of original meaning, but he was very much in favor of saying, yeah, according to 197, you have to appropriate it by law. You have to have a statute in order to appropriate money. Okay, so basically, Parliament was right and Charles I was wrong in 1640. All that business. So if you remember, the 1620s had all these, the 30s had all this stuff about ship money, and there's all the great Stuart kings getting tied down by Parliament. And a lot of the same provisions are basically end up in the Constitution. So they're like, yeah, okay, Parliament was right, and we put 197 in order to vindicate the parliamentary position. But if they want to give an open-ended delegation, that's not going to be a problem under Article 1, Section 9, Clause 7. If there's a problem with open-ended delegation, it's because it essentially takes the legislative power and gives it to the executive. That's something a lot of people have wanted the court to get more energetic about, but that claim itself was not in the CFPB case. So you have the CFPB and these other people, CFAA. They were the litigants. So two, and I think they're both consumer finance or something. But those litigants, because they didn't raise a delegation argument as such based on just legislative power, their 197 claim loses. So both of those were that was 7-2. Alito and Gorsuch dissented. It was a little unclear exactly what limit they wanted to have. There is a provision in the Constitution about Army appropriations not being able to be longer than 2 years. Given that provision, it really does seem like Thomas is right that when the people writing the Constitution put in a temporal limit, like with the Army, they did it explicitly. So the background seems to be pretty clearly that other than that, you can have it be last as long as you want. But it is. It is, I think, an extremely concerning abdication of congressional responsibility to say, like, well, how long is this supposed to last? How much are you supposed to spend? What are you supposed to be doing? Isn't it your job as legislators to pass the laws? And the CFPB and, hundreds of other agencies, but really, a dozen big ones just make all kinds of laws that these could be statutes. There's no reason why Congress can't get in the game and get those done. So those are the two big ones, and I'm looking at 10 more.
Wow,
really big ones to come. But we'll I'll torment you about those when they come out. Maybe
it seems like of the last 2 or 3 years, maybe this is just a function of having divided government, and so much policy emanates from the chief executive, from the White House, that the court has been dealing a lot with cases that involve situations where did the commander-in-chief kind of extend beyond his legal boundaries here? That the Consumer Finance Protection Bureau, it even involved the way it was funded, right, Professor? That was a big question, the actual agency itself.
That's right. They had an earlier case where they said that the CFPB was too insulated from the president. So they basically gave the agency within which it was contained authority to remove the CFPB. So that was one of the structural problems. But the kind of indefinite funding, they ended up saying, was not. But, I mean, in an era where you've got an increasingly polarized electorate,
right,
and you elect the president one way, and then 4 years later, it really, because this stuff isn't written down in the U.S. Code,
right,
you get these wild swings. And if we had a system where Congress was required to do their job and actually say what the rules were, they would have to compromise. So neither side would get entirely what they want. But the way it is now, one side gets, more or less entirely what they want for 4 years, and then everybody gets unhappy, and then puts in another guy, and the other side is unhappy, is perfectly happy for 4 years. So it really is, I don't think, any good way to run a railroad. So you look at the anti-delegation principles of the founders. One way to think of it is that it really is a doctrine that is well suited for exactly this time like we have now, where you've got all this disagreement. And in order to avoid swinging back and forth, if you just lock the door and say, look, you just can't delegate a legislative power to the agencies, you have to compromise, they will come up with something.
Yeah.
So the median voter is going to have a lot more power in that system instead of the median of each party, which is they're just really far apart. And it's this is kind of end of the republic type stuff.
We're up against a break. If you can hang around, we'll continue this discussion and dig into this trial up in New York.
Sure.
Yeah, we got law professor Christopher Green on with us. We're coming right back in the Element Wealth studio. We're visiting with law professor Christopher Green. So just kind of wrap up the issue with the Supreme Court. It just seems like not only, Professor, are these cases tying up our court and kind of filling the docket up with challenges to the executive branch making decisions and issuing policies that perhaps aren't completely conferred to the executive in law. And the other thing we're seeing is how that's playing out at the state level. Look no further than our state. We've got recent new changes in policy regarding Title IX coming from the Biden administration. And so our Attorney General is joined with other Attorney Generals in now suing the Biden administration for those changes.
Yeah, the Title IX stuff is just a classic example where we've got this statute back from 1972, and it talks about discrimination because of sex, and the court itself has dealt with kind of a very similar question in the Bostock case about what exactly that covers. Just Congress has never been forced to resolve these things. And actually, the Title IX, when they adopted it in '72, they were actually a lot more elaborate about a lot of these things. So there was specific things about women's athletics. So you might remember the 9 for 9 series on ESPN, talking about all these women athletics. That's a direct result of these specific provisions in the statute. But then all of this just extensions of it into transgender rights and all that are something that they were kind of on the radar screen in '72. They could have been if they had pulled up the radar screen and looked at like the distant perimeter of it, maybe on the edges of things, but they just didn't define it, and it just really seems like a kind of classic legislative type thing. But one of the big cases to come, it's actually, I hope they title it Relentless. So there's two cases. One is Relentless and one is Loper Bright. So Relentless would be a much more fun case name. But they're about whether agencies get deference about the meaning of statutes. It'll probably, that'll get probably discarded before any of the Title IX stuff comes down. But if it gets rid of Chevron deference, then the whole question for these Title IX cases is going to be completely different. It's going to be the meaning of the statute as such, not whether the agency was within a zone of reasonableness about how to interpret it.
Well, it seems like that it's keeping the courts busy because the executive keeps changing policies or essentially what appears to me to be modifying law or certainly overstepping their boundaries when the Congress makes law, and that I think that's a function, as you indicated, of the polarization of the nation and just the fact that the Congress can't agrees on precious little, and so the executive steps in to just push forth an agenda through executive orders, and we're probably going to continue to see that. Let's turn our attention to this Trump trial. First, can you just explain to the audience exactly what the crime is he's being charged with?
So ordinarily you think that's the easy question, but that's really one of the more probably about the most complicated thing you can ask about this. So what exactly are we talking about? Okay, so we've got. The linchpin, the kind of the weird bank shot. I feel like it's a kind of a triple bank shot, but the weirdest of the bank shots is this campaign finance element. So the idea is you're supposed to tell people about bad stuff that you did in your past. Okay, that's the kind of the basic idea. So if you had an affair with a porn star and paid her some money. I guess even if you're being blackmailed, if you didn't have an affair and somebody just comes and says, well, I'm threatening to go to the press about it. So because of that campaign finance aspect, the way that the Trump people characterize their payments to Michael Cohen matters. So because that matters, then these business records that they keep about characterizing what that was for. So Cohen says, "Oh yeah, I gave this porn star a bunch of money." Actually, I think he said, "I charged Trump for more than that." So in his testimony, he said, "Well, yeah, I just sort of stole some money from Trump. I thought, well, he's not going to call me on it, so I'll just bill him for more than that." So Cohen is really quite a character, puts it mildly, but he has some credibility problems. But of course, Trump has some credibility problems for all kinds of reasons. So the argument is by mischaracterizing the nature of Cohen's services, Trump was evading federal campaign finance rules, which of course the federal prosecutors haven't touched with a 10-foot pole. I mean, maybe they touched it with a 10-foot pole. They did not prosecute it as a federal thing. So we've got these state courts coming in and saying, we want to, by means of our local state business records laws, second-guess the decision not to go after Trump about, this being a campaign contribution. Yeah, so the idea is like, by hushing up whatever he did with Stormy Daniels, this is a campaign contribution. So, but it kind of, it's a kind of a triple bank shot, but or quadruple or whatever. But sometimes you can make those work, and you look at the indictment, like, well, you kind of look at there's 3 or 4 things. You're like, maybe. And it kind of all holds together, but that's all you have to do if you're a prosecutor. Make it all hold together well enough to get it to a jury, and then. And then you get to have all these salacious details come out in court, and of course you cause the president to want to say stuff. He just can't seem to keep his mouth shut about these gag orders. So then there's giving him all these little fines and maybe putting him in jail for just the meta stuff. Yeah, it triggers all this meta stuff. Yeah. All the meta stuff about the gag order could conceivably put him in jail. But if the jury comes back and convicts him, then you have a question of when you're going to sentence him and what the sentence would be. Would the sentence itself include some kind of jail time? It could, but again, this is the massive discretion you have both prosecutors and with judges in terms of sentencing, which is. Traditionally, this is kind of how we do it. I think there's been reform proposals made, all throughout American history about, hey, do we want to rein in discretion of the prosecutors and judges? But it's been increasing over time. So I'm mildly optimistic. I'm as optimistic as I ever am about this kind of thing. That maybe people are going to look at these laws and just say how broad they are and say, hey, maybe we should require prosecutors to show that they're prosecuting similar people, to keep records, to have policies, all that kind of stuff. We were talking about agencies. I really think of prosecutors, DA's offices as pretty closely akin to a rogue agency. So we require agencies to explain themselves. When you get this back and forth with administrations, when they change their mind, they have to give an explanation, a reasoned explanation for why they're doing it. If you just require prosecutors to give a reasoned explanation of why are you picking this guy out of all the people who have business records that are maybe close to the line, why are you picking this guy? You got to have some kind of policy. I don't know if we're going to adopt it anytime super soon, but I think it would be a good idea. And if Trump raises the profile of it, all the better.
Well, yeah, it's kind of hard to imagine that it's not there's not some political motivation in here. When I can't think of another case where someone was brought into court for falsifying business records where there was really no one hurt. I mean, and there's no victim. The same problem he's got with the other case he has in New York, which deals with that.
This is the kind of thing. Think of Martha Stewart. Martha Stewart didn't go to jail for insider trading. She went to jail for lying to the FBI about
insider trading. Yeah.
And you look through the list of criminal offenses. In the Title 97 of the Mississippi Code or 18 U.S. Code. They're just filled. I mean, piles and piles and piles of laws about making dishonest statements in context X, Y, and Z, and virtually none of these are ever prosecuted. But when if you just really, really are mad at somebody, you get these people something happens and some prosecutor says, well, I searched through the thing. I can't find anything to go after this person. Everybody agrees we want to go after them. The legislature, let's never let that happen again. Let's pass some more of these. You don't have to prosecute them. But if if the day comes when someday you need to go after somebody for doing something dodgy, well, now you've got, 1,750 ways to do it instead of just 1,749.
We got 5 seconds left. Do you have a prediction on it?
Oh, about Trump? I would assume if they're competently picked on their jury, they'll convict. But I don't know. There's been some sloppiness, so he could win.
Yep.
Maybe.
Appreciate it, Professor Christopher Green. Thanks for coming on. Always enjoy your insight. Thank you.
Good talking to you, sir.
Yeah, man.